If you're accepting credit cards from your clients, you're likely absorbing 2.5 to 3.5% in fees on every transaction. For an MSP processing $50,000 a month, that's $18,000 a year just in fees, and that comes straight out of your margin. Surcharging is one way to offset that, but it comes with rules, real legal risk, and a few things that people commonly get wrong. So let's break it down. A credit card surcharge is a fee you add to an invoice or bill for when a client pays with credit card, specifically to cover the high processing costs that come with credit cards. It's different from a late fee or a convenience fee. A surcharge is a pass-through, so instead of you paying that 2 to 4% processing fee, you pass that on to your client as a surcharge. So how much can you surcharge? There are three main things that control how much you can surcharge. That's the credit card companies themselves, federal law, and state law. Let's start with the credit card companies. Visa and Mastercard have to follow strict regulations, and they expect you to follow those same regulations as well. That means surcharges are capped at 3% for Visa and 4% for Mastercard, and they can never exceed your actual cost of processing. If you break their rules, they can restrict service and fine you up to $25,000. And that's just from Visa. That doesn't cover government penalties. Speaking of government regulations, federally, credit card surcharging is legal. What's not legal is surcharging debit cards. Under federal law, specifically the Durbin Amendment, surcharging debit card transactions is prohibited everywhere in the US, with no exceptions. It doesn't matter if the card was processed with a PIN or without one. So if you're turning on surcharging, make sure your payment platform can detect card types. The final component on how much you can surcharge is based on state-specific laws and regulations. This is where it gets even more complicated. While you can surcharge credit cards, it's not legal everywhere. As of 2026, surcharging is outright prohibited in Massachusetts, Maine, and Connecticut. So if you or your clients are operating in one of these states, surcharging is off of the table. Beyond the prohibited states, multiple states have specific laws about how surcharges need to be disclosed, how they appear on receipts, and how they're even billed, and whether they apply to B2B transactions the same way they apply to consumer transactions. It's not a one-size-fits-all situation. For example, New York only legalized surcharging in 2024, but it's with strict requirements. You have to post the total credit card price, including the surcharge, before the transaction takes place. You can't just add it to the end of the invoice. Otherwise, you could incur a civil penalty of up to $500 per violation. And then there's Texas, which technically has laws banning surcharging, but in 2018 they found that law to be unenforceable. So surcharging is allowed in Texas, but it exists in what their own law would call a legal gray area, meaning you're still fully on the hook for following card network laws at the federal level. The bottom line is before you implement surcharging, you need to check the laws in both your state and your client states if you provide services outside of where your LLC is based. The thing with surcharging is it's entirely optional for you as the merchant, and this actually allows for a lot of flexibility. You can waive surcharges for your VIP clients. You could only surcharge for invoices over $5,000. You could also split the surcharge. So if the credit card processing fee is 3%, you could absorb that 1.5% and pass on the other 1.5%. And that's a great way to offer flexibility without injuring your client relationships. If surcharging is legal where you operate, there are a few rules for how you have to do it. For example, you have to notify your card networks at least 30 days before you implement surcharging. You can't just switch it on. You also have to disclose the surcharge before clients pay. Clients also need to be able to choose a different payment method if they don't want to pay that fee. Non-compliance can result in significant repercussions. Depending on the violation, penalties can run from $1,000 to $150,000. On top of that, the card networks can pull your ability to charge credit cards altogether. So, should you do it? Surcharging does make a lot of sense for MSPs who have large recurring contracts that are paid for by their client who prefers credit cards. Again, processing $50,000 a month in credit card payments means around $18,000 a year in fees just gone. But surcharging isn't free of friction either. Some clients push back, and you need tooling that handles it properly, detecting card type, disclosing the fee properly, and giving clients a choice. That's why the better conversation is usually around ACH. ACH processing fees are a fraction of what it costs to process credit cards. So on a $5,000 invoice, that could look like paying 50 cents instead of $125. And with same-day ACH, funds can settle in the same day, so you're not giving up the speed. The trade-off is just that some clients prefer paying with card. In that case, surcharging becomes the tool that effectively encourages your clients to choose a payment method that costs you both less. A lot of MSPs end up doing both, offering ACH as a default and still accepting credit cards, but with a surcharge applied. At that point, they just let their clients decide what's most important to them. Surcharging can be a legitimate tool for protecting your margins, but it has to be done right, legally, compliantly, and with full transparency for your clients. If you want to dig into state-by-state rules, FlexPoint has a full guide at getflexpoint.com. And if you're using FlexPoint for billing, surcharging support is built in, with automatic card detection, so debit cards are automatically excluded.